Welcome to, I'm trying to think, is this our first in-person first virtual training for the year? I think it is. My name is Barbara Reddick, and I'm with the Southwest Georgia Housing Task Force. I'm a member of the task force. Our chairperson or director is Pat Fletcher, and Ms. Sonia Johnson is our co-chair. The Southwest Georgia Housing Task Force started, I want to say, like in 2000. So that's a long time ago. It didn't seem like a long time when I said it, but it is. And it started out in a plan. It was just something on a piece of paper, and it ended up being a group of housing stakeholders around the region that have banded together and stay together really to educate and find resources for residents and communities in our region. And our mission is to identify affordable housing solutions. And our goal, we seek to have representation from all of our 14 counties. We cover Region 10, so that's 14 counties and 43 cities. And part of one thing that we do is provide these educational sessions throughout the year to inform and provide information to homeowners, just the general public. And this is one that I think we've done one similar to this, and it was very popular. So we thought we would repeat it. We're partnering this morning with Georgia Legal Services, Shaina Thompson, and is that Meta Brown? You all can correct me, but I'm gonna let them come on in just a few minutes and introduce themselves, and I'm gonna get out of the way. Ladies, I am turning it over to you.
Thank you so much. Good morning, everyone. My name is Shaina Thompson. I am the Supervisor Housing Advice Line Attorney at Georgia Legal Services. And before I get started, Meta, I'm going to go ahead and let you introduce yourself as well.
Good morning as well. My name is Meta Brown. I am in the housing division for the rental assistance unit, where I am a housing navigator. Where we concentrate on the eviction process and rental assistance.
Great. So I just want to thank you so much for giving us the opportunity to speak on the housing issues that we're seeing today. We're going to be talking about navigating the eviction and the rental assistance process. And I want to go over the agenda of what we're going to be talking about today. So we'll give you a brief overview of Georgia Legal Services program. We'll talk about some tenant rights and some responsibility. We'll give a brief overview of the new retaliation law in Georgia. And we'll spend a good deal of time talking about the eviction process. After I finish talking about the eviction process, I'm going to open up for any questions that may be there. And then I will probably do maybe like a couple of minute break before we get into the Georgia rental assistance portion of the training. And I'll turn that over to Meta at that time. And then after she gets finished with discussing all of the ins and outs and the new developments with the Georgia rental assistance, I will come back and just talk about some ways that you can mitigate tension with the landlord. And then we'll talk about some possible resources. So we'll go ahead and get started. And I am trying to move the slides. Let's see if they're working. Okay, so Georgia Legal Services, we are a statewide nonprofit law firm that serves 154 counties in the state of Georgia. We provide free legal services for clients that are eligible, and we only do civil matters. We don't do anything criminal. We have about 10 offices in the state of Georgia: Albany, Athens, Atlanta, Augusta, Brunswick, Columbus, Dalton, Gainesville, Macon, Piedmont, Savannah. And then we also have a farm workers' right division as well. And it's our mission that we provide legal services to people with low incomes to create equal opportunities and equal access to justice. We always tell people we want to make sure that everyone has a seat at the table. So the civil areas of law that we cover are going to be your economic securities, your education, work rights, and family law, health law, housing, and consumer law. And for today's presentation, we are definitely going to just hone in on that housing law that's been kind of ramping up a little bit since COVID. So tenant rights in Georgia. Before we get started on the tenant rights, I do want to just let everyone know that Georgia law is very landlord friendly, which means that a lot of the laws are good for the landlords and not so great for the tenant. However, there are some tenant rights, and because the laws are landlord friendly, it is very important that you do know the rights you do have. So who are tenants? Tenants are going to be someone that has an agreement with the owner to possess the property. Now, this agreement can be either a written agreement or it can be an oral agreement. Regardless, if there's an agreement that you can possess the property, you are going to be considered a tenant. Now, hotel guests are generally not tenants because of their transit nature. And you do have a little bit of a blurred line when it comes to if you're a tenant or if you're a boarder, especially for those staying in extended stay hotels. We recently had a new case come out this year, and it's called Efficiency Lodge Incorporated versus Nelson, and that really dived in a little bit about how you can differentiate if you're a tenant or if you're a boarder. And for Georgia law, you're going to have like some different fact patterns to go through, but for the most part, if you have an agreement to stay inside of the property and you're not a hotel guest and you're not in a transit nature, you're going to be considered a tenant. It's very important for those tenants who do not have a lease agreement to understand that your agreement is really going to center around the verbal agreement and the verbal understanding of what the agreement entails, but also this notice requirement that Georgia law has for those who do not have a lease agreement. And that notice requirement is going to be if a tenant wants to end the agreement, they have to give a 60 days notice. If the landlord wants to end the agreement, they have to give if the tenant wants to end the agreement, they have to give a 30 days notice. If the landlord wants to end the agreement, they have to give a 60 days notice. And also with that also comes the notice requirement for changing any of their agreements. So let's say that at first you had an agreement that you couldn't have dogs inside of the property, or that you could have dogs inside of the property. If the landlord wants to change that and say, nope, I changed my mind, then they are going to have to give you a 60 days notice. And that rule, the new rule, will not apply until after that 60 days notice have went. Tenants have the right to quiet enjoyment of property, and they have the right to have guests. They also have a right for reasonable notice before the landlord enters the rental property. Now, here in Georgia, the law does not give a particular time frame. In other states, there's a particular time frame. Just in Georgia, it says reasonable notice. So the other right that tenants have is that they can enforce the terms of the lease agreement. So if there is a written lease agreement, you definitely have a right to enforce whatever is in that lease agreement. One of the important elements and rights that tenants have is a process before an actual eviction occurs. Now that is different from those that are considered a hotel resident. If you are a tenant, then your landlord is going to have to go through what is called a dispensary process to get you removed from the property. They cannot do any self-help evictions, and self-help evictions can be anything from locking you out, turning off the utilities, anything that they're doing to try to get you to move out of the property without going through the court process. That's self-help, and it is illegal in Georgia. One of the main issues that we see in landlord-tenant issues in general is going to be the repairs. So repairs, the repair issue in Georgia is that landlords have the duty to make repairs. They have a duty to make repairs after you have given them notice of the repair issue, and they have to give you, you have to give them reasonable time, and then they have to make the repairs. Now, one thing that is very important to know about the repair issue is that landlords cannot try to waive their duty to make repairs. We see a lot of landlords that put in their contract or something that the tenant is going to be responsible for the repairs and not the actual landlord. They cannot do that. And in that case that I mentioned prior, the Efficiency Lodge Incorporated versus Nelson actually even hammered that home, where it said not only can landlords not waive the landlord's duty to make repairs in a lease agreement, they can't do that in any contract. If any contract, any agreement, whether it's oral, whether it's in writing, they can't try to waive their duty to make repairs or any duties that the landlords have underneath as far as the tenant's rights. So that's very important, and we're very happy that that case came out and clarified some issues with that. The tenant may also be able to sue the landlord who violates their duties, and then they can also be, the landlord can also have some fines for violating housing codes. Usually you have a local ordinance enforcement group that will help with that, and so they can definitely have fines, and the house can also be condemned. An important issue is that while landlords have a duty to make repairs, tenants have a duty to pay the rent. Those duties do not cancel one out. So a lot of people think that if the landlord is not making repairs, they can just stop paying rent. And landlords think that if the tenant is not paying rent, they can stop making repairs. That is not how Georgia works. Landlord has the duty to make repairs, tenant has a duty to pay the rent, regardless of what the other person is doing on that instance. Georgia law does have about 4 ways you can address repairs, and we've already talked about contacting maybe code enforcement or the code enforcement. I'm gonna really spend some time with the 3 other ways that you can, tenants can address repairs. The first one is called the repair and deduct, and that is where the tenant pays for the repairs and deducts the cost from the landlord from the rent for the next month. Now, in order to do that, there are some steps that the tenant must actually make to make sure that they're doing everything that they need to do to make sure that they can have this argument that they've done repair and deduct. The first step is to put your landlord on notice that there is an issue that needs to be repaired. We usually tell tenants to make sure that that notice is in writing, so you have evidence that you did put the landlord on notice. The next step is to give the landlord reasonable time to make repairs. Again, Georgia doesn't really give you a time frame of what's reasonable, but we usually tell tenants to think about, you know, how serious the issue is. You know, if it's a light that's not quite working, you may can give them, you know, a couple of days on that. If it's a toilet that's overflowing and there's sewage everywhere, you know, that's something that needs to be addressed immediately. So that's where you're going to use to try to determine the reasonable time. After you've given the landlord reasonable time to make the repairs and they still have not made it, you put them on notice again. You tell them that you're going to do the repair and deduct if they don't make the repairs by a certain time. After that has occurred, then you make the repairs using a licensed contractor. Don't use Uncle Jojo, because if he's not licensed, then they can, you know, there's a whole bunch of can of worms that can be opened up with that. So you want to make sure that you use a licensed contractor. And then the next step is that you will deduct it from your next month's rent. And not that month, the next month's rent. And how you do that is, let's say that your rent is $500. We wish that rent was $500 in this housing market, but let's say it's for $500. And the repair that's needed was $250. You would take that receipt, the itemized receipt from that licensed contractor that has a $250 on there, and then you would combine it with the $250 that's left for the remaining part of the rent, and you give it to your landlord and say, this is my rent, I'm making, I'm, you know, doing my repair and deduct. There is a risk with that, and that the landlord may still file a dispensary for non-payment. That is why it's so important for you to follow the steps and make sure you have a paper trail, because that will be a defense, a possible defense in the eviction case of non-payment, because you can show that you did your repair and deduct and you did everything you needed to do underneath Georgia law. The next way is called diminution of value, and it's basically stating that you have not received what you contracted for. And I will give an example for that as well. You can raise this as a counterclaim in your eviction for non-payment. And how that works, it says, let's say that you rented a 2-bedroom, 2-bathroom apartment, but you haven't had the use of one of the bathrooms. So you're not getting what you contracted for, even if it's a verbal agreement. You're not getting the use of a 2-bedroom, 2-bathroom. What you're getting is a use of a 2-bedroom, 1-bathroom. And so let's say that 2-bedroom, 2-bathroom is $750. And the 2-bedroom, 1-bathroom is $550. Basically, what you should be paying for rent is the $550 and not the $750 during the months that you had you didn't have the use of the full use of what you contracted for. So that's how you would calculate that diminution of value claim as a counterclaim, and ask for reimbursement for the $200 that you've been paying over, or ask for the judge to reduce the rent until the landlord actually makes those repairs. The third way is constructive eviction, and a lot of people try to argue this, and this is where they get in trouble, where they just stop paying rent and just saying, he's not making repairs, she's not making repairs, I'm not paying rent anymore, I shouldn't have to live in this bad environment, they're a slumlord, whatever the case may be. And they think that they're doing this constructive eviction. Constructive eviction means that the landlord has failed to make repairs and it's made the unit uninhabitable. Now, uninhabitable does not mean uncomfortable. It means that it is no longer safe and sanitary for a human person to live inside of the property. And that's a very important element, because you can't say that it's a constructive eviction if you're still living inside of the property. That goes against your argument that it's to such a state that no human person could live there. Out of my time of taking cases to court and arguing repair issues, there has only been a handful of times where I'm able to actually prove a constructive eviction for a possible defense in a non-payment suit. So it's very hard to prove, and that big element is whether you're still living inside the property. There are two rights that I want to talk about, which deals with terminating the lease early. The first one deals with those who are victims of domestic violence or family violence, or who have gotten a protective order. And so you can, in fact, Georgia law allows you to terminate your lease agreement early. There are some steps though. You have to give a 30-day termination notice, and you have to also attach a copy of the protective order to that termination notice. If you don't have the 1-year protective order and you just have the ex parte, then you have to attach the police report to that 30 days notice. You're still responsible for rent during the 30 days. That's very important. Still responsible for rent during the 30 days. If you do everything that you're supposed to do as it relates to those steps, then you will not be charged the early termination fee. So that's the first way. The second one is when you're a member of the armed services. Members of armed services can also terminate their lease early without any penalty after giving a 30 days notice and giving a copy of the orders saying that they have to move 35 miles away from where they're living, or they have to live in government quarters. Again, even the service member, they're still responsible for the rent during that 30-day notice period. Security deposits is another important element that I want to discuss because there's a lot of misconceptions as far as the security deposit is concerned. First of all, the security deposit does not come into play until after you've terminated the lease or surrendered the premises, and it's been 30 days. We get a lot of people calling and just say, hey, it's been a week, I haven't gotten my security deposit. The landlord is not required to give any security deposit until it's been 30 days. That does not come into play. Another big thing is that the landlord is not allowed to keep the security deposit for normal wear and tear. So we're going to talk about normal wear and tear is, if you've been living inside of the property for 10 years and the walls need to be repainted, that's normal wear and tear. Now, if there's holes in the walls, if your kid decided to do, their beautiful artwork on the wall or something like that, that's different. But for normal wear and tear, where there's little scuffs and things of that nature, they're not going to be able to just deduct that from your security deposit. Another caveat that people need to be aware of is that if your landlord is what we call a big landlord, they have some other steps that they have to make as it relates to the security deposit is concerned. And so those big landlords are going to be those that own 10 or more properties. This includes immediate family, if the immediate family members also own some properties in that 10 number, or if they use a property manager to collect rent. So if they do that, there are two things that they're supposed to do as it relates to the security deposit. One is prior to the move in, and one is right after the move out. They're supposed to provide you with the move in checklist stating the existing damages so that you have that. And then they're supposed to provide you with a move out checklist with the damages they're allegedly saying that you caused so that you can compare that. If both of those lists are not provided, the landlord is not allowed by Georgia law to charge or to deduct anything from the landlord, from the tenant's security deposit. However, they can still deduct if there's unpaid rent. Now, I want to, before we go into retaliation, I do want to spend some time on that because people get a little confused with that because they're just like, okay, well, the landlord can take my security deposit for unpaid rent. Again, remember that the security deposit does not come into play until after you've moved out and after it's been 30 days. You can't say that I'm not really late on rent because I've already paid my security deposit. My security deposit covers 1 month or 2 months rent. No, Georgia law does not allow that. The security deposit is for damages as it relates to after you move out. Now, Georgia's new retaliation law, it protects tenants from being retaliated against from the landlords if after they have requested repairs or they've contacted code enforcement. Now, this can be a successful defense against eviction. If you prove that the landlord has retaliated against you, you've requested repairs, and within 3 months, the landlord has terminated the lease agreement, the landlord can be, there can be a judgment for you for the landlord to pay the tenant 1 month's rent plus $500. So that protection protects you for 3 months. If your landlord files an eviction, deprives you of any possessions or otherwise breaches the lease agreement, you can be protected if you have asked for repairs or contacted code enforcement. There is a presumption that if this happens within the 3 months, that the landlord has retaliated against you. However, the landlord can bring evidence to show that they really did not. Now, there are some caveats to this. This retaliation defense goes out the window if at any point you are late on rent. It goes out the window if at any point you legitimately violate the lease agreement. It goes out the window if your lease was set to expire at the end of the month and you stayed there. It goes out the window if any of those things happen. So you want to make sure, the other thing, it goes out the window if you give the landlord saying, I'm tired of this, these houses falling down, I'm just going to be gone in the next 30 days. And then you decide, oh, it's really hard for me to find a house, I need to stay a little bit. That defense goes out the window. So you need to make sure that none of those things occur for you to have a successful retaliation defense. Now we're going to get into the eviction process. There are 3 main reasons that the landlord files an eviction. One is going to be for non-payment of rent. That's a big one, especially now during COVID. People are not, being able to find jobs or having to stay out of work because of COVID-related issues. So non-payment is a big thing, and we don't have any COVID protections anymore. We do not have those anymore. The next thing is going to be that the lease ends or that there is some type of lease violations. The main defenses that we have for different dispensaries are going to be that tender defense. A tender defense is that you pay everything you owe plus court costs, and you have to pay that within your 7-day answer period. If it's on the 8th day, your landlord does not have to accept it. If it's on the 8th day, the courts can't force your landlord to accept it. You have 7 days to assert that tender defense and pay everything plus court costs. And what we usually say is pay everything that's allegedly owed and then argue about the amount that you actually owe later, because you want to make sure that you're using that defense and actually being covered by it. You can only use that once every 12 months. So once you use it, you lose it. So you can't use that and then 3 months or 6 months down the road, try to use that again. It's a one-time deal every 12 months with that landlord. We've already talked about the retaliation, how that can be a defense to non-payment. Discrimination is also a defense, and you can't be discriminated against based on race, sex, disability, religion, and familial status. If you have a history of making partial payments, your like every month you're making a payment on the 1st and on the 10th, and that's how you've been doing it for the last couple of months, your landlord can't then after the first say, okay, I'm filing eviction because I didn't get the whole payment. However, the landlord can go back to the original lease terms of the agreement. So how that would have to happen is that, let's say that you try to pay your rent, half of the rent on the 1st, then your landlord would say, okay, I am accepting this, but I have to let you know that come next month or in the next few days, I want to go back to the original lease terms because I can't continue to accept partial payments. They do have to put you on that notice before they file the eviction if they have a history of accepting partial payments. Terminating the lease that's not proper underneath the lease term. So this really occurs when you have like a 1 month lease agreement, a 1 year lease agreement, and then after a couple of months, the landlord is just like, yeah, this is not working, no reason behind it, I'm just going to terminate the agreement. They can't do that. Whatever the contract states, they have to kind of go by that contract. And then failure to repair, again, this is not going to prevent an eviction. If you're talking about repair issues, this is not going to prevent eviction from going forward unless the damage that you claim is greater than the amount you owe. So let's say that you owe $750 and you can show that the damage is for $700. That $50 will still get you an eviction. So you need to make sure that if you're going to be arguing that it does cover the amount that you actually owe. Unemployment or other financial hardships are not legal defenses, and especially, we had the moratorium for a while, and so COVID protected us. Those protections are no longer in place. So other financial hardships are not going to be a defense to non-payment dispensaries. And again, we talked about the security deposit not applying to your unpaid rent. The eviction process is usually that the landlord will file into the magistrate courts. They can file in state and superior court, but usually they'll file in the magistrate courts. After they file, the sheriffs will serve the tenant with the court papers, and that shouldn't and will include the summons and the complaint. You can be served 2 different ways, in person or by tack and mail. And that tack and mail is that the sheriffs tack it to your door and put a copy of it in your mailbox. The notice for demand of property to vacate is required under Georgia law, but that notice is not the summons. So your landlord tacking some paper that has their letterhead on it saying that you need to be out in 3 days, that is not the notice. It's going to be an official summons and complaint from the courts that is going to apply as far as this eviction process. The tenant has 7 days after the date of being served to answer. That 7 days is 7 calendar days. That's not business days, work days. The weekends count. If your 7th day ends on a Saturday or Sunday, then the next business day is going to occur. Is going to be when your answer is due. If it ends on a Monday and that's a holiday and the courts are closed, then the next business day is when your answer is going to be due. Please file your answer in court. We get a lot of tenants thinking that they done what they're supposed to do, because all it says is to file an answer or to make your answer, and they call the courthouse and just say, hey, this is what's happening and blah, blah, blah. That's not filing an answer. They think emailing the judge saying, I got this notice and he did this and X, Y, or emailing the courts, that's not filing an answer. Contacting your landlord and saying, hey, why did you do this? I thought we had an agreement, blah, blah, blah. That's not filing an answer. You have to file your answer in court. Make sure it has that court file stamp on it. Some courts allow you to do it by e-filing. Even that will have that court file stamping. That is how you know when it has a court file stamping. That is how you know that you filed your answer in court. Most courts have the forms that the tenants can fill out that has how, whether you admit or deny, and other little check boxes that you can add, and then your counterclaim section. It's very important that if you do not raise the defenses that we talked about, or defenses in general in your answer, you cannot bring it up in court. So you want to make sure that you are adding everything that you may want to say in court. Now, don't put things that are unrelated, but you want to make sure that you have your defenses in there so that the other side can object to you bringing those things up in court. Most courts allow the tenant to amend their answer all the way up into the hearing. And so you want to make sure that you're using those provisions provided for you to make sure that you have all your defenses. So if your answer is late, let's say that you don't answer within that 7 day, an immediate writ can be issued. That means that next day, the landlord can start that process of getting the sheriffs to come out and put your items out. If you are served in person, that there may be the writ of possession in the money judgment for the amount that you owe or anything of that nature. If you're served by tack and mail, the courts haven't really established jurisdiction over you, so they can give the landlord the writ of possession, but they can't give them a money judgment. You want to make sure that your answer is filed timely. After it's filed timely, then the courts will schedule your hearing, usually within 7 days. Right now, it may be a little bit more than 7 days because of the pandemic, but we're seeing that lessen now. And it's very unlikely that the courts will allow you to continue the hearing date unless your landlord is in agreement, or unless you can show that you are in the hospital or something like that. But you do have to put the courts on notice prior to the hearing. And so you want to make sure that you have all your ducks in a row if that's the case. At the hearing, the judge may ask the parties to try to go through a settlement, or there may be a mediator. So those are possibilities. Not all courts require that, but that may be a possibility. The other thing the tenant needs to be aware of is that any evidence that they want to bring up in court, they have to have it there that day. Any witnesses they want to testify needs to be there that day. The witnesses can't write a letter, sign saying this is what happened, signature, and I tell the truth. That's not going to fly. You're going to have your evidence. You can't tell the judge, well, I have that at home. If we can reschedule, that's not going to fly. Any evidence that you have, you want to make sure you bring 3 copies, and the 3 copies is for yourself, the other party, and the judge, so that when you are talking about your evidence, everyone has an opportunity to look at it. If you show up to your hearing late, this is very important. If you don't show up, or if you show up to your hearing late, even 5 minutes late, even 2 minutes late, I've heard a story where the judge literally called the docket, the person was not there, the judge issued the writ of possession, the immediate writ of possession, and the person came back and came in court and was just like, oh, I'm here. Judge was like, it's done. You want to make sure that you are on time for your hearing, because immediate writ can be issued where the judge strikes the answer. And if an immediate writ is issued, or if there's a default judgment, you do not have an appeal process. That's it. The judge will probably announce the decision in court. There have been times where the case was very close and the judge needed to go under advisement, so it took them a couple of days to actually announce the decision, but that's not normal. Usually they're going to announce the decision in court. The sheriff can start to execute that writ as soon as the 8th day. So we usually tell people you have 7 days to appeal, come to an agreement with your landlord, or to move out of the property once that writ of possession is issued. After that, on the 8th day, the landlord can start the execution process of the writ of possession, and it's really up to the sheriff's schedule. We've already talked about the appeal process. And so the actual set out and removal process is that once that 8th day occur and they have the sheriffs, they executed the writ, they have the sheriffs there, they can remove all of your personal property and they can put it on their property. Sometimes the sheriff will agree for the landlords to put it on the street or on the sidewalk. Once that occurs, that process occurs, then your property is considered abandoned. And so it's pretty much a free for all. So we always tell people, you know, make sure you're protecting your property, make sure you have a plan for whatever you need to do, a U-Haul, have people there, whatever you need to do to make sure that your property is protected, because once it's out there, it is pretty much considered abandoned. So that was a lot of information, and I do want to open up for anyone that may have some questions. So I'll give it a few minutes, and if no one has questions, we'll do maybe a 3-minute break.
I did have a question, but I think you answered it in one of the slides. It was about the tenant making the repairs and, you know, just making them and then deducting it from the rent. But I think you said that the tenant would have to give the landlord, I guess, notice or let them make them aware of what repairs needed to be done and give them the opportunity to make the repairs, as well as use a licensed contractor, not Uncle Joe or Brother Bob or somebody like that.
Yes, and that's very important. If you make the repairs yourself, you're not giving your landlord the opportunity to meet their duty. So you have to put them on notice that you're going to do the repair and deducts and give them reasonable time to make the repair before you do that. And I know that that's a lot of steps for people. It's just like, you know, I've been living with this situation for 2 months. I'm just going to do it myself. But you have to go through those different steps. Put them on notice, give them reasonable time. Put them on notice again that you're going to do the repair and deduct, have a licensed contractor, and then have that receipt to show the price that you actually paid.
May I ask a question? Good morning, everyone. I'm Shirley Ingram. Ms. Thompson, what is considered as reasonable time?
So yes,
open-ended. I'm sorry.
it is, and a lot of people get frustrated with that. Unfortunately, a lot of Georgia laws are kind of open-ended and use that reasonable language. The reasonable is not going to be a clear-cut answer. It's going to be where you have to determine the height of the issue. Like, how is it an emergency issue? And I use the example, like if your light is flickering, that can, you know, you can go like a couple of days, even a week with that issue of a flickering light. But if your toilet is overflowing and there's sewage everywhere, that's something that has to be addressed immediately. Yes. So what we usually tell people is that, is it going to shock the judge? Because that's pretty much what you're working with as far as reasonable time. If you go into court and say, my toilet was overflowing and there was sewage everywhere and it took the landlord a week to come in, that's going to be shocking. The judge is going to be like, what's going on? Like, there's children here, whatever. If you say, it took him a week to fix my flickering light, is that going to shock the judge? It probably won't. And the judge is like, I think that's reasonable.
Yes. Okay, thank you.
Great question.
Hey, all right, my name is Shaina Stevens, and I have a question as well.
Okay.
So, my question is, if, say for instance, you've been living somewhere for 20 years, or just any amount of time, I guess, and they make repairs, or they renovate the property, and then they say they up the price due to the renovation. And they say that they give you a 30-day notice. Either you're gonna pay the increase in the rent plus a new deposit. Is that allowed?
So you said, so I'm going to ask a couple questions. Is there a lease agreement that has been, that's still in place that hasn't expired.
Yes.
So if there is a lease agreement that hasn't expired, now let me clarify that, because usually the lease agreement will say this lease agreement is for a year and it will continue on as a month-to-month tenancy. Now, if it says that, that lease agreement has expired. Now, the terms can still be applied, but it doesn't have that duration for a year. You're going to be considered a month-to-month tenant. If that is the case, then they have to give you 60 days notice before they change anything. So that 30 days notice is not enough. They will have to give you 60 days notice. And unfortunately, yes, they can say in 60 days, we've made all of these repairs and we've renovated the property. We're giving you 60 days notice that we're going to increase the rent. And in addition to that, either sign a new lease agreement, or we're also going to do a new security deposit, or you have to move. They can do that if you're a month-to-month tenant and there's not a lease agreement that has a duration, that you're not still underneath the duration of the lease agreement. They can do that, but those different changes will not apply until after the 60 days. They can't ask you to pay that increased rent until after day 61. Those things apply if you haven't moved.
Okay, so it is a year-to-year apartment complex actually. So, and you renew your lease every year. So yeah.
So if you just signed a new lease agreement, you have a lease agreement that has terms of the agreement, and it is still like you just signed a new lease agreement. It says a year. They can't just up your rent unless the lease agreement states that. Now, we live in a country where there's freedom of contract, and so if the contract says we can change any terms of this lease agreement by giving you a 30 days notice, that's the rule of thumb. Your contract is going to be like your blueprint to your landlord-tenant relationship. If it says that they can change anything within 30 days by giving you a 30 days notice, they can do that. So what I always tell people is to make sure that you really read your lease agreement. A lot of people don't go through the ins and outs and read the lease agreement. I would read it, I would highlight it, I would tab it, because you want to make sure that you are fully aware of all of the ins and outs and what can be detrimental to you. And unfortunately, in this market where the housing market, the laws are landlord friendly and there's not affordable housing, landlords be putting any and everything in their contracts. So it makes it difficult, but you want to make sure that you know that. And you also want to make sure there's nothing in that contract that's saying that you waive this right and you waive that right. Even if it's in there, that part of the lease agreement will not be upheld in Georgia.
Okay, and I have one more question. Now, is there a max fee on a pet deposit?
No, again, we live in a country that there's freedom of contract. If you agree to pay $1,000 for a pet fee and the person down the street is only paying $200, that's your negotiation and bargaining. You agree to that. So, there are some ways where you can probably argue that if the contract is ambiguous or that the person didn't really understand the terms of the contract, but that's really far in between, because people, especially in Georgia, put a big emphasis on people's freedom to contract. We are not going to parent you. You have freedom to say what you're willing to do and what you're not willing to do. And if you sign it and agree, and there's nothing on its face that looks like anything fraudulent has occurred, we're going to go by that agreement.
All right, thank you.
Mm-hmm.
Yes, I do. I guess you said all of the housing task force member asking questions.
Go ahead. I wanted people to understand. So
okay, I just see this. It seems like it's becoming a trend, like non-refundable fees, like application fees, credit. Is there any limit to that, or what are maybe some legal, maybe non-refundable fees? And they tag them on, like with the application, and you'll have this fee and this fee and this fee. But if you don't, it's not refundable.
So again, that goes back to that freedom of contract aspect. If it's in the agreement and you stated and you were willing to sign that off, then, you know, the judge is going to pretty much go by that agreement. Now, if it's something extreme, again, if it's something extreme where the judge, where it's ambiguous and the judge knows that there's no way that anyone would have agreed to that, then, you know, the judge can strike different agreements inside, different things inside of the contract. But that, again, is very far in between. If it's clear that they're saying that these are going to be the fees that's tacked on if you do X, Y, and Z, and you sign off on it, those fees are going to govern. There is one fee that I do see that, and this is, there is one fee that I see that's in contracts a lot, and landlords pretty much do not apply this correctly, and it's attorney's fees. Usually in the contract, it will say that the prevailing party is entitled to attorney's fees. But what we see landlords doing is, as soon as an eviction is filed, they're tacking on those legal fees and their attorney's fees. That, by the contract, is illegal. In the contract, it says the prevailing party. Just because you filed something in court does not mean you're a prevailing party. Until there is a judgment by the court or something like that, there is no prevailing party. I'm not going to, you know, the tenant is not responsible for those attorney's fees if that contract says the prevailing party. That's one fee that we see a lot, and one fee that we also push back on. The other issue is that it'll say that the landlord is entitled to reasonable attorney's fees. And believe it or not, Georgia statute actually has a mathematic equation of calculating reasonable attorney's fees. It's not just, you know, whatever the attorney feels is reasonable. There is a calculation on that. So that's another thing that we see that people just don't realize that you can kind of push back on.
Okay. And I got one other thing.
Okay.
Okay.
I'm going to take one more question, and then I would just ask for everyone to kind of put it in the chat and let us try to address it at the end, so that the Meta can do her amazing thing and talk to you guys about rental assistance, because there's a lot of new things going on, and I want to make sure that we give time for that.
Okay. Well, I try to roll this into one question because it's similar. Can you not allow pets, or can you keep people say, I don't want smoking on the property? Are these legal? Can you do that? I know it's hard to police some of these things, but you can. Can you put that in a lease?
Yes, you can prevent pets from being in the lease agreement. Now, what you do have is you have a little gray area when we're talking about emotional support dogs, and we're talking about dogs that are needed for disabilities. We talked about that they can't discriminate against you because of your disability, your sex, your religion, and all of the different lists. They can't say that you can't live here because you have to have an emotional support dog, or that you need a dog for disability. They have to do a reasonable accommodations for that. But you also have to have your paperwork, you know, for all of that. And you do have to put your landlord on notice that this is what this dog is, and then there is a way of doing requesting for reasonable accommodations for those particular things. But as far as like them saying you can't have dogs here, they can do that. Saying you can't have a particular person come to the house, that would really kind of infringe upon your quiet enjoyment. But now they can't say that you can't have people there for more than 7 days and stuff like that, because then it's more like that goes to whether the person is actually living at the property and it's not listed on the lease as an actual tenant. So those are a little bit of some gray area things right there, and it just depends on the fact of the case.
Okay, does smoking, can you say no smoking on the property?
Yeah, they can prevent smoking. So you have, and a lot these days, you have that issue where there's the no smoking rule. So again, it really just goes back to if the contract says no smoking and you say, yep, that's fine with me, the courts are not going to say, well, the courts are not going to say that's discrimination or whatnot. On the face of the contract, it said no smoking, and that applies to everyone. As long as it applies to everyone, you know. Now, if they have 3 tenants down the road and they know that they're smoking, they're over there just having smoking parties, and they don't say anything to them, and then they want to say something to you, then you can bring that up.
Okay. All right. Thank you.
Okay. All right, Meta, I am going to bring it over to you. And if you guys have more questions, leave them to the end, because we'll have another question and answer. And I'll try to, like, if I see anything in the chat, I'll try to address those as well.
Okay, now we're going into venturing into the rental assistance part of the PowerPoint. So next screen, please. So GLSP is working throughout the state to avoid eviction by helping the tenants to access rental assistance through the Georgia Rental Assistance Program, which we commonly refer to as GRA, and it's administered by the Georgia Department of Community Affairs, which you will hear me refer to as DCA and GRA throughout this session. Georgia has approximately 1.2 billion through the Emergency Rental Assistance Program, the ERAP, administered by the U.S. Department of Treasury. DCA has received approximately 990 million of that allocation, with the remainder going to local programs. Okay, next screen. What this involves, the application process is the completion of an online application and uploading of documents that establish eligibility. So what happens is that the client calls in if they're doing a process with GLSP, and they do a preliminary intake with the intake specialist, give them the information, and they go through the criteria. Once they meet that preliminary eligibility, then they send the information to one of us, where they're assigned to a housing navigator as myself. The tenants are required to submit significant amounts of information and documents to support the application for GRA. We get a lot of pushback a lot of times because it is very, very personal, the information that we ask for. It's not our standards or protocol. It is what the federal government requires. So it's very detailed. For many tenants, the process is a significant barrier where they cannot submit the application to accessing rental assistance because many tenants don't have a computer and the application is not mobile phone friendly. A lot of tenants, especially the younger clients, like to do everything on their cell phone, and this particular application is just not user friendly on the phone. Converting the payments to electronic for uploading is challenging for the tenants. They don't understand that, how to change them into the PDF and JPEG form. So we have a lot of problems with that. Rural areas do not have access to Wi-Fi or DSL. So a lot of the older clients prefer to mail in. And when they do, that slows down the process. Downloading the required forms for signature, where we have to do a e-sign. They do not understand that at all. And that's a significant barrier for a lot of the tenants. And the tenants have difficulty determining what documents are relevant and upload unnecessary documents. And this slows down the process. A lot of tenants will upload where they show where they had an accident with their car. They upload their COVID test forms. They upload where their child may have been hospitalized. They upload a lot of things that have nothing to do with the rental assistance process, but it shows us that yes, you need the assistance, but that's not what they're asking for. Next screen. Because the barriers created by the online process, this is why the rental assistance unit was created, and it's staffed by the housing navigators. And not only addition with the housing navigators, when a applicant calls into Georgia Legal Services, they get myself, who is a housing navigator. If they're in the process of having a pending eviction, they also are assigned a housing attorney, which would be someone like Shaina or whoever else is on the housing attorney of the rental assistance team. Any client who has previously filed the application, we try to correct those applications, because a lot of times there are some clients just upload the same document. It could be a birth certificate, which is not something that they need, but they will put that in every required form. And so we try to resolve these issues. Once I get in contact with the client, I let them know what required document is needed to support their application. And by submitting the properly completed application and uploading all the necessary documentation, the documents, they meet the criteria for eligibility, and then it can speed up the approval process. What I have to make the clients understand is that Georgia Legal Service does not process or fund any application. And that's a hard thing for them to understand, because you're talking to me. So of course they think that we have something to do with the application process. We make sure that the documentation that's needed to support the application is there, but we do not process the application, nor do we fund the application. That is strictly DCA. They do all of that. They also assign the processor. A lot of times, once we go through that, that preliminary thing, process of uploading the application and having the documentation there, they want to know, when is it going to be processed, which is a natural response. We don't have a timeline for that. Once it is assigned by DCA, it's strictly up to them when it will be reviewed and when it will be processed. I also let them know that there may be additional information or documentation that will be needed to support the application, because we get a lot of pushback, at least from the clients, who saying, I thought I gave you everything. That's the preliminary. That's not everything that you need to process your application. Next screen. So the arrears are anything, as you know, you have a lot of clients say, well, when we ask, how much do you owe? This is always something that we get sometimes 4 or 5 different answers. They'll say, well, I'm past due this month. So we need to know everything that you're past due. Since COVID, some clients have not made payment since the year 2019. And because COVID hit, well, it was recognized on March 19, I think March 19, 2019. So they have not made payment since then, believe it or not. So when we say, what do you owe? They'll say, oh, about this much, or I think I owe this much, or I know I haven't paid this much. So we have to, it's an exact figure. So we always ask for the ledger. A ledger would give us the payment history of what the client has done. It's because when we turn in something to the federal government, we can't say the client owes about this much. We have to match that information with what the client states that they owe and what the landlord states what they owe. So when the client fills out an application, and if the landlord participates later on in these screens, you will see that the information has to match. And if there's a discrepancy, that will also delay the process. Rent payments, future rent payments, if a client states that, say for instance, they owe, this is the month of October, and they stated that they owe August and September. So they stated to me, I already know that I'm past due 3 months. And I asked them, will you be able to pay in November? And they said, probably not. So I asked them, do you need any future rent payments? And they'll say, yes. You can have up to 3 months of future months payments that DCA will allow you to, for the first time, for initial rental assistance. That's initial rental assistance. That's the first time that you apply for rental assistance. So the first time that you apply, you can ask for 3 months. And these are 3 month increments. A lot of clients state, I applied and I put in for 18 months. Why didn't I receive 18 months of payment? 18 months is the maximum amount of assistance that you can receive. And it would not be dispersed all at once. They will pay the information based on the information that was put in by the client and by the landlord. or what you stated was your arrears and your past due rent, or if you also put in future rent, but they will not give you 18 months of payment. It doesn't work like that. They also will pay for utility assistance. That utility assistance may be for your water, your power bill, the sewage sometimes is connected to that, and the trash. You will see that later on when that's broken down and itemized as well. Next screen, please. GRA will cover the amounts due after March 13, 2020. So that's the date. And I think COVID came into play. This is when the governor of the state of Georgia recognized COVID as the pandemic that hit nationwide. There's an 18-month limit on the total number a month, as I just discussed, of assistance that a tenant can receive. And that's the combination of past and future rent payments. As I stated, 18 months will not be slated for payment at once. And a lot of applicants mistakenly believe that they are going to be approved for 18 months for right off the rip. They think that because of the fact that they're reading that they have an 18-month limit, but that's not the case. You have to apply for future rent after your initial assistance. You still have to be recertified every 3 months if you need additional assistance. The amount of assistance for each household is not limited. Georgia does not say that you only get $25,000, $15,000. Initially, that's what they started with. They gave a cap, but now there's no cap. Payment of reasonably late fees can be covered, but limited to 8% of the total arrearage. We have clients who say, I owe $30,000. They give us documentation for that. The landlord gives us documentation, and it may state that the client owes $45,000. Once they give it in, submit the ledger and give it to DCA. Once it's verified, they're only going to pay 8% of that. The client then calls me back and say, hey, you all didn't pay but X amount of dollars. This is why we always stress it's only going to be 8% of that. The landlord will call and say they only pay X amount of dollars. As we say, we let them know up front, which nobody reads. When the landlord submits their application, they will see that it's only 8%. When the client submits their application, they will see that the payment is only going to be 8%. We quote that as well. That month, the money that is not covered by the 8%, the client and landlord have to come to some type of negotiation. And that's where the housing attorney comes in. Sometimes they can negotiate that and say, will you accept that as being paid once you accept the GRA payment? Sometimes that happens, sometimes that doesn't. But this is what GRA is going to pay. And a lot of times they don't agree with that. Payment of reasonably late fees are covered, but are not limited to the 8% of the arrears. As we said, the legal fees and other charges to the landlord are not eligible for GRA payments. Landlords who receive a direct payment for GRA, this is very important, agree to waive the accrued late fees above the 8% of the total arrears. A lot of times they don't agree. The landlord will accept the payment and then they will come back and say, I didn't agree to that. This is where the housing attorney comes in and they have to speak to that landlord. Many times we have that problem with that. Accepting the GR payment as a full payment for the amount due for the month paid and dismiss any pending eviction action. A lot of times the landlord will accept those payments, they will accept the future renter payments, and then they'll file for eviction. And the client will call and say, they're still evicting me after you all have paid. And Someone said they can't hear. I don't know if that's for me or not. Can you all hear me?
I
Yes,
can, yes, I
Okay,
can. I can.
okay,
It might be them, it might be them. They're
okay.
not. I'm not
Um,
sure.
But at any rate, a lot of times we have a lot of discrepancy with that. And this is where initially the housing attorneys were used to try to implement the rental agreement where the landlord signed. The landlords now will not sign the housing agreement. A lot of times they will participate and accept the payment, but they will not sign the the rental agreement, because they stated that legally they felt as though that they didn't get a better deal out of it. At least that's what one landlord was stated to me. So this is why we have to make sure that they understand when they accept that payment, this is what's supposed to happen. But a lot of the landlords have also found a loophole. They accept the payment, they get the future rent payments, and then they will inflate the monthly rent where the client cannot afford it anymore. And either the client has to leave or they will start the eviction process again when the client cannot pay. So that's been happening quite a bit. The next screen, please. Utility assistance. Eligible utility payments include electric, natural gas, water, sewer, trash removal, and energy costs such as fuel. This is important because a lot of clients, unfortunately, have this problem where I wish the DCA would separate the utility, which they do, but they usually pay the utility bill at the same time of rental assistance. So if their application is being held up where they need additional information to process the rental assistance, so is the utility assistance. A lot of times the power has been disconnected because the application is being delayed. Therefore, clients are calling because they have the power cut off, they have the water shut off. And we call DCA and let them know this client applied for utility assistance, but they haven't processed the rental assistance side, so they don't process the utility side, which is insane. So you have two issues that you're dealing with. And as Shaina has spoken about, you need the immediate assistance on the utility side. We've been trying to work with that and tell them that this is something when a client applies for utility assistance, that's immediate need. And the rental assistance, even if there's a delay, that's something that can wait, even though we know that sometimes there's an eviction pending, but sometimes you have a little bit more time with that. But when you have the utility system, especially when you're dealing with the environment and with the climate, when it's hot, when it's cold, you need to make sure that they have the utility assistance first. Telecommunication services such as phone and cable, they have recently said that we're not covered, but recently DCA changes so much, we cannot keep up with it. Right now, they were saying that they were accepting internet. So if your internet was part, a lot of apartments have where the internet is included with some of the costs and some of the packages with an apartment, they were including that temporarily. And then they shut that down. We can't keep up with when they stop and when they start. We don't always get the most recent information. We just have to work with it until we're told differently. If a utility charge is paid to the landlord by the tenant and identified in the lease, they will pay those charges, not as a utility payment, but as part of as the monthly rent. But it has to be identified as part of the rent and not just something separately. Next screen, please. Future rent, as I said, they pay in 3 months increments. And if there's been a prior award where they're still in possession of the property, the applicant can request this future rent, but it's not a given. It's not automatic. If a client receives future rent where they have been paid 3 months previously, it's not an automatic thing. They have to recertify and they have to submit the recertification application again to receive additional assistance. And a lot of them don't understand that. They will call and say, Ms. Brown, why didn't I get my rent paid for this month? Because you did not submit the future rent application. They have to make sure that they submit it. If they're still in need of additional assistance, they have to submit the future rent application. And those forms are on the website under a tab slated as required documents. And they're the last 3 forms slated as recertification forms. That's what they're called. And this applicant must submit the following. It's a recertification of income. You either submit the annual or the monthly, supporting documentation for each household member of age of 18 and up, recertification of household composition form that describes any changes of the current household members. So it's basically you submit 2 of the recertification forms and information that supports your income. That's what you submit for recertification. A lot of times clients submit everything and we're not asking, they will resubmit the application again. If they submit the application again, what happens is, which is a no-no, what happens is that the application status will change to duplicate. And that delays the process. When that happens, I will no longer have access in real time of what the status is. I have a client who submitted application 3 times. So she has 3 applications on file. So I no longer have access to it. She has to call DCA for any status updates. She gets upset because when she calls me, she wants information and I can't give her information because now her information is in their database and I don't have access to that. They can only tell her which application is active and which one they're using to say that this is what they're going by. And once they do that, they flag it because they don't know if they're trying to defraud them. They don't know if she's using a different social security number, if someone else in her household is seeking rental assistance. So it just goes into a myriad of a lot of things that happens when they do another application. And we try to urge them not to, because a lot of clients get impatient. They don't want to wait on the process. They say it's been a month, so I just filed another application. But that's not how it works. With the federal government, they're on their own timetable. So we don't have anything to do with how long it takes, unfortunately. We just try to ensure them that it will happen, but it's a process of waiting. Next screen, please. Other housing assistance. When this happens, more than likely the client is no longer in possession of the property. And what happens is that the client, when they file the application, they were in possession of the property, but during the waiting period of them filing and submitting the application, they were evicted. But they can file and still receive funding for the time that they possess the property. I hope I make that clear to everyone. So while they were there, they filed the application, they were in possession, they got evicted, and they can file and they can still have the application on file, and they can still receive funding for the time that they were in possession of it. So they state that they're going to a hotel. What happens is the cost of the hotel, a payment, they were paying for a 30-day period. And we asked for a hotel folio. What the hotel folio is that it just gives an itemized account of a 1 day period for 30 days, and it's itemized plus tax. and it sums it up for that total amount for 30 days. Extensions are permitted up to an additional 2 months. Now, after the 30 days, if they are funded for this, they have to show receipts that they stayed there, because we have had clients who are funded with the money and they say, well, I decided to stay with my aunt. Or I had a friend who said that if I just gave them $500, I can stay there. We can't demand that they stay in a hotel, but they are not eligible for any more additional other housing assistance because they did not use it for a hotel. So it is not a reimbursable pre-approved thing. So I say that up front, that they're not going to pay for when you go to the hotel or you go online, they're not going to pay you up front for you making a reservation. They're not going to reimburse you if you've already gone to the hotel and paid for the hotel and you say, I'm here and I need you to send me a check. That's not how it works. You have to send in the hotel folio. You also have to show where there was a writ that shows that you were evicted, and you send in that information to myself, to the housing navigator. It's uploaded. I message the processor and I let them know that you are now no longer in possession of the property, and I upload the folio along with the writ and I send it in and let them know that you're not applying for other housing assistance. And as it states, you need the proof of eviction and the hotel folio. Next screen, please. Moving costs. Now they do cover with other housing. I'm sorry, I'm just reading this question. If a client's permanent resident is at a hotel, are they eligible for assistance? For permanent residents, so are you stating that the client that's the only place they have ever been? Am I understanding that? Okay. So from the way that the housing assistance works is that they have to have been in a property before they can apply for housing assistance. I've yet to see them assist anyone where their address has been a hotel. It has to be where they have been in a property, and for whatever reason, we have a client who lived in a hotel for a year or more. I have to get more information on that, but we've never had anyone who their permanent address was a hotel. It's always been where the other assistance has come into play, where a client has been evicted from their former residence, and then they move into a hotel. The moving costs. On moving costs, covered expenses is from moving from a house, no monetary cap or limit on this, but it's subject to review for market rate for reasonable analysis. The documentation is the vendor proposal or estimate and reservation information. And I always make sure that I try to explain to the client, get the information of what the estimates of the moving costs is. And if they do any out of pocket, that does not mean that they will pay for the moving costs right away. You're responsible if you go ahead and move. Some clients say, well, Ms. Brown, I had to move. And I understand that. I didn't have a choice. They have to move. I make sure that they have the receipts. So it's totally up to them who they choose to move. But I let them know that also with the process with DCA, that they will ask for those receipts, and especially with the moving costs and with storage. Also with storage, it's also just like with the hotel folio, every 3 months, they can send in that receipt so they can pay for another 3 months of recertification. It's like recertification with storage. I have a client who sends in her receipts every 3 months. She sends in her receipts for her storage fee. So she does that on a regular basis, and DCA pays for that storage fee. I have another question. Does hotel rating matters or hinders hotel expense pre? No, the hotel, each individual is responsible for doing their own research and the cost of where they choose to stay in a hotel. We do no steering, no suggestion. It's totally individual where they want to stay. It's up to them about if they want to stay in a 5-star or 1-star. It's totally up to the individual. Next screen, please. GRA eligibility. So we go, as you know, household income is no more than 80% of the current area median income. When a client calls in after they do the preliminary with the intake, we go to income. We go to the AMI index screen. I put in the zip code. I put in the county and the city for that area. It also asks me, based on the preliminary intake, how many people are in that household, and it brings me up the median for that area. It gives me a high and a low. So I base that on the information that was taken by intake. If they're too high, then that's what I quote to the client, and I will state that your income is too high for this program. Sometimes we have that. Sometimes they slip through. Sometimes people will give false information and say that, they're lower income. And when they send in their tax information and when it's uploaded to the portal, the processor will contact me and say, Ms. Brown, this client does not qualify based on their income. A lot of clients don't realize that even though you quote us one thing, they have to show verification. They have to show proof of income. They have to show proof of who's in the household. So we have to make sure that what they say to us is verified. So it's totally up to DCA, because when they send in the information, we have to verify about all of that information, even though it's preliminary with us. Once it gets to DCA, they make the final determination of who's eligible. You also have to be renting property in Georgia. I had a client who was she says she was on the line, but she said she was in Brunswick, but she was actually in Florida. This is Georgia rental assistance. So I had to stress that to her. You're in need of assistance and you're at risk of homelessness also. Next screen, please. Need income documentation for the income. This is more of the eligibility. You need income documentation for all individuals over the age of 18 who reside in the household full time with no other place of residence. This is very important. Some clients will say, well, I have a child, but they live with me. Sometimes on the weekend, 2 months out the year. I ask them, do they stay with you 6 months out of the year? Then they're considered a resident. So we have to be very, very careful about who's in the household. Clients who say, my boyfriend left. He used to be here, but he's on the lease. We have a lot of that. If they're on the lease and they're no longer there, we have to have a written letter that's with verification stating that that person is no longer there. Because once it gets to DCA, they're going to ask for ID, income, and verification of that person still being, because they stated that they are a resident of that property, and they get upset with us because they state that they're no longer there, but you're showing that they're on the lease. So they show that proves to us that they were a resident. So you have to show us that they're no longer there. Social Security numbers are requested for each household. Everybody, newborn babies, all the way up. We have to have Social Security numbers for everyone in the household. If there's a member of the household that has no income or no documentation of income, there's an income documentation waiver under required documents tab on the portal website that you have to complete. There's also a separate form for self-employment income. And I have copies of those that I can send to you all so you can see what they look like. They're very user-friendly, but for some reason, the income documentation waiver stresses people out a lot, because if you click on, it says no qualifying income, there's a blank box in the middle. You have to provide a written statement as to why you have no income or a lapse in income, because it requires, if you have income, you have to show proof of income for 90 days. So if you do not have income, you have to state why you don't have income, or your lapse of income, why you did not have income the past 90 days. And for some reason, a lot of people mess that form up. So we usually assist them with that form. Next screen, please. Renting property in Georgia, the eligibility documentation, DCA prefers the tenant provide an unexpired written lease signed by both parties and all pages attached along with the signature page. With the lease must have all pages, including the signature page. Some of these leases are 80 pages long, including the signature page. And DCA wants every page. I will never understand it, but they do. They want every single page. If not available, DCA will need proof that the tenant lives in the property and has paid rent in the past. Documentation could include any written lease, even if it's expired. We need that because that will establish tenancy, that you were a tenant. Lacking the signatures of the tenant and the landlord, a ledger is most preferable in my opinion, because it shows the payment history and it also establishes tenancy. A statement from the landlord stating that the tenant lives in the unit and owes rent. If they're sending you a past due notice, it's establishing tenancy. But DCA doesn't see it like that. It's not as black or white for them, so they prefer the ledger and the past due notice. Also, if they have an eviction notice, you would think that that would be acceptable, but that's not DCA. They will accept the eviction notice, they will accept the past due notice, and they still want a ledger or a lease. Any written communication between the landlord and tenant which acknowledges the landlord and tenant's relationship. That's the texts, the emails or whatever that they're stating, hey, you owe us X amount of dollars. When are you going to pay? Any type of communication between that landlord and tenant, they want that information because that establishes also the landlord and tenant relationship. Evidence that the tenant is paying utilities for the resident unit. We have a lot of issues with this because a lot of tenants will have the utilities in someone else's name. So when it comes to that, when they say, okay, well, my lease is expired. I said, okay, well, what about your power bill? Well, that's in my sister's name or my mother's name. What about a phone bill? Well, I got my phone bill in my child's name. So it's sometimes very, very difficult to get documentation that you have proof of tenancy. Yeah, you're saying, well, I've been here the last 3 years, but right now you can't prove that. And so we have to do a lot. We also will accept the welcome letter. If a tenant, sometimes tenants have that, the welcome letter from the actual property, welcome them, stating that welcome to whatever property, and it would give the outline, the rent, the security deposit, the security deposit, first month rent, all of that, that's acceptable by DCA. So that's always great. But a lot of tenants do not keep the welcome letter. If they're Section 8, the recertification, that's acceptable if they don't have the utilities or anything. That in the form of a lease, that's always acceptable. Evidence that the tenant uses the property address as the official mailing address or address for official documents. The voting card. as I said, if they don't have the utility bill, we need something that states that they live there. That's the most important thing. And a lot of times it's very, very difficult. When we don't have it, we usually try to resort to the instability form, and that'll come up later. Next screen, please. Need eligibility documentation. To be eligible for GRA, the household must demonstrate that they are at risk of experiencing homelessness or experiencing housing instability. A lot of times tenants will call and say, well, I'm not late, but I heard that I can get some money. And they say it just that blunt. And I say, oh, you're at risk of losing your home? No. Are you past due? No. But I know that there's money out there for people. So as I stated, they have to prove that they are experiencing homelessness or they have some type of housing instability. An eviction note, demand to pay, past due rent notice, a past due utility notice. Those are the things that we're looking for. Just because you heard about the program or you may decide that you don't want to pay your rent is not an excuse or a need or eligibility for rental assistance. If no past due rent is owed, they can complete the housing instability form stating that they are experiencing a housing burden. That's different from saying that I just don't want to pay my rent this month because I plan on doing something else with my money. You're stating that your rent is greater than 40% of my income. Foregoing or delaying the purchase of food, prescription medication, childcare, or similar essential necessity. I have a client who stated that because she was paying out so much for her childcare, she was making the rent, but she was barely making the rent. So she was in need of rental assistance because she stated that she was barely able to make her rent. And she knew if she faltered just by anything, she was at risk. So that's a different thing of you just saying, I don't want to pay my rent this month. Next screen. Every household must complete and upload the COVID hardship form. This is where a lot of clients get really confused. They think that we're asking for the COVID testing. We get screenshots where they have taken the home test at home. We get screenshots where they got the doctor's letters or statements stating that they have tested positive. This is not what they're asking for. It's the COVID hardship attestation form is a form stating that you have been impacted because of COVID with your inability to pay. Now it can be related to COVID, it can be unrelated to COVID, but you have experienced some type of hardship due to this. And every applicant has to complete this form. It's no exception. Everyone has to have this form. This is also under the required documents tab in the portal. Next screen, please. At the time of filing for rental assistance, the tenant must be living in the property. I had a tenant who stated that she was not in the property. She had moved out. She was living with her mother, but she wanted to file rental assistance. She was not eligible. And I could not make her understand that. She said, she said, my landlord is going to sue me because I owe rent. Yes, she still owed, but she was no longer in possession of the property. Households that live in a unit where the landlord has a family relationship, they're related to the landlord. Anyone in the household may be eligible, but they must provide documentation that a true landlord-tenant relationship exists. Just because it's auntie and you all have had the relationship that sometimes you pay and sometimes you don't, it has to be an established landlord-tenant relationship in order for you to apply for rental assistance. This would include a copy of a lease, as well as verification of past rental payment history of no less than 6 months. And we have a lot of issues with that, where I had a client where her father was her landlord. but she didn't have any documentation of what she was truly paying rent. She said she was paying rent. She may have been paying rent, but because it was her father, she was allowed to sometime pay and sometime not. So that became an issue where she couldn't show proof of tenancy. The related landlord cannot reside at the property as households where a household member holds the title of the property, title to the property are not eligible. So the related landlord cannot reside at the property as households where a household member holds the title of the property are not eligible. Okay, next screen, please. Mobile homes are eligible for rental assistance on the unit being rented. If the mobile home is owned by the applicant, rent assistance may be requested for the lot rented. So let me say that again. Mobile homes are eligible for rental assistance on the unit being rented if the mobile home is owned by the applicant and rent assistance is requested for the lot being rented. So a lot of people get a misconception there and they call in about the mobile home. So that needs to be stressed about the lot. Assistance under this program is allowed for households temporarily residing in a hotel, motel, or temporary lodging if the landlord-tenant relationship and a lease agreement is in place. So as we stated earlier about this, if a client has already filed for rental assistance and they had to leave the property due to an eviction, they can file for, well, the application is already submitted. They can file for other assistance and get assistance due to that being established that they were in the property when the application was filed. Next screen, please. Payments. Generally, payments are made to the landlord because, as Shaina stated, Georgia they're inclined to favor for the landlord, and this program was made for the landlord. This program, the concept was due to the pandemic, landlord was not being paid due to the moratorium. So we have to make sure that the clients understand that. Clients call us and say, hey, where's my check? This program was designed for the landlord. It was designed for them because they were being paid due to the pandemic. Okay, so generally they're made to the landlord. Only if the landlord agrees to accept the payment and provide DCA with the required information. If they do not, the payments can be made directly to a household. So what that means is, can you go back to that screen? Excuse me. Yeah, what that means is if the landlord participates with the program, the landlord has to go to the portal. They have to create an account. They have to submit an application just like the tenant that shows that they're participating. Their application is then linked to the tenant application. They can monitor the tenant application from their portal. They get the same updates that the tenant will get. The landlord will be required to submit supporting documentation. Tenant will be supported for supporting documentation. Then if the landlord decides, hey, if they don't want to do all of that, I'm not participating, they call the DCA will always contact the landlord, whether they participate or not. They will always give them the opportunity to participate. A tenant will say, oh, my landlord is not going to participate. They already told me. They don't take word of mouth. They have to have verification that they are not participating. A landlord can participate up to pending payment for going directly to a client. So to be certain, so let me explain that. When a client states that their landlord is not participating, landlord has not participated, they said, no, I'm not going to do it. I don't want to do it. I just want this client out, whatever. The client has decided that, you know, they're going for it, which they can go for it. They don't have to have the landlord participation. They do a direct payment to the client. It's pending in the portal. The landlord can still put in an application, create an application, submit it, and that payment can then go to the landlord while the payment is pending. The client, we have to make sure that the client understands that, because the client a lot of times will call and say, what happened to my payment? Well, it went to the landlord, because it's not obligated to go to, as long as it's pending, it can go to the landlord, still has the opportunity to receive the payment. If the landlord evicts the tenant while the GR application is, wait a minute, is pending, DCAA would issue the payment directly to the tenant, okay? Now, that's changed, as I just stated, DCAA changes all the time. So that's changed. The tenant must submit an ACH form. That's the form that, you know, for your banking, it puts all your banking information. It asks for your routing number, asks for your checking number. The tenant and the landlord fills it out. Once the landlord submits an application, they ask for that automatically so that they will have the banking information on file. Also, utility payments will be paid directly to the, it used to be paid directly to the tenant, but now they pay it directly to the provider, the power company, the water company, whoever. So that's what they used to do, because a lot of times the tenant will receive the payment and then they wouldn't pay the utility company, and then they would say that they haven't received the payment. So they started paying it directly to the utility company. Okay, next screen, please. Okay, mitigate the tension. Okay, all right, I'm hurrying. Staying in communication with your landlord. We always urge the clients to stay in communication. This is where a lot of things break down, where they don't have a lot. When the communication breaks down, then you have a landlord they say, I haven't heard from them in over a year. That happens. Continue to attempt to pay something toward the amount owed. Act before the dispo is filed. That's what we try to urge the client. Don't wait on Georgia Legal to reach out to your landlord. You reach out to your landlord. Try to renegotiate the lease terms with the landlord and develop a plan in writing. Get that in writing. If the landlord agrees to give you more time, get the agreement in writing. Access rental assistance early. A lot of times we have clients who call and they're on the last day before set out. Last day. So, you know, so that's what happened. Next screen, please. Okay.
So I wanted to, Miss Barbara and Ms. Shaina, is it okay if I address a couple of questions that came up in the chat real quickly? I know that we're over.
Sure, yes, ma'am, go ahead.
Okay, so I'm just on, first of all, these are some resources that can, for the tenant, you know, Georgia Legal Services is our website. There's the Georgia Landlord Tenant Handbook, and then you can always call 211 for United Way. As far as the questions that were in the chat, I'm gonna quickly address them, and then I'll give an opportunity to, for people to ask a question. Just, I know that we're over time, so I won't feel, you know, anyway, if you log off, as long as that's fine with Miss Barbara and Miss Shaina, then we'll answer questions. So as Meta just mentioned, the late fees, the Georgia Rental Assistance will not pay anything over the 8%. If the landlord accepts the rental assistance, those late fees are, anything over that is waived. Now, there is a gray area when it comes to other fees and attorney's fees. We kind of talked about the whole issues with attorney's fees. Georgia Rental Assistance does not pay the attorney's fees, and the landlord does not waive attorney's fees. So while they waive anything over the 8% of the rent, other late fees that are associated with the eviction and whatnot that are not addressed by Georgia Rental Assistance are still fair game, and the tenant is still responsible for that. One way is Meta, she it mentioned how landlords are really good with coming up with loopholes. One of those loopholes is whether they accept the payment directly. If the landlord is accepting the payment directly, that's when that 8% comes into play. If they tell the tenant that I'm not accepting the payment directly, but if you want to give me the money after you receive it, then I'll accept it, then they don't have to waive any of those they don't have to comply with the 8% or anything like that. So that's one of the loopholes that they're using. A question was asked about whether a person was living in a hotel or an extended stay. So again, it goes back to whether you can establish that landlord-tenant relationship. If you can establish that landlord-tenant relationship and the landlord is willing to say, yes, they're a tenant and submit documentation for that, then the rental assistance will definitely apply for it. The other thing was that Meta mentioned that I just want to highlight is that what we have a lot, especially in Savannah, is where I'm located. We have a lot of people where they have these houses where they're renting out rooms, and Meta definitely made a statement stating that if the owner is living inside of the property, you cannot get rental assistance. So if the owner, even if you're not related to them, if the owner is living inside of the property and renting out their rooms, related or not, you're not going to be eligible for rental assistance. So that's a big thing. And then another thing that was mentioned was the mobile homes. And I just want to clarify why that's the reason for the mobile homes. Underneath Georgia law, you can own your mobile home and still have a landlord-tenant relationship with the person that you're renting the lot with. So if you own, you can have, it's two situations where you're renting the mobile home and the lot, or you're just renting the lot. If you're just renting the lot, you can still get the rental assistance because you're still going to have that landlord-tenant relationship because you're renting the lot. So those are just some caveats that are a little bit more difficult as far as Georgia law that I just wanted to clarify. Someone said that they had a question, so I definitely want to give you that opportunity to answer, for me to answer your question if I can.
Hi, this is Sharon Edwards. I'm calling from Thomasville, Georgia. We're a nonprofit organization where we work with several of those in the rural areas that do not have access to computers. So they'll come to our office and we'll help them complete their application and submit their documents. Some of the issues we have is that we do not have the landlords that are interested, like I said, in participating. And some of the landlords, they will go, or they will come in and they'll ask us to help with that. Do you have other organizations around the state that are actually helping with that? Because we began to get a little overwhelmed because we have so many that were coming in when they found out we were able to help do the application. So we were kind of had to start limiting when they could come in because so many in the rural areas or the elderly just really don't have access or know how to upload their documents.
So what Meta, you can go ahead.
Okay, what I was going to quickly say is when we deal with the rural areas, one of the things that I have been advising them to do is to go to a senior center for those who are elderly to help them with this with doing the application and uploading documents. And also if they're close to a GLSP office, to go in person where we can also send them information and the documents where they can be printed out and they can send them back to us and scan them back to us. So.
And just to answer your question, as far as if there's other organizations that's doing it, there are. What I will say is that we're seeing less and less organizations participating and helping with the rental assistance. And I think it's because it's just at this point, it's been going on for such a long time and resources are being pulled from every which way. So what we are seeing is that less and less outside organizations outside of the Georgia Rental Assistance is actually continuing on with the rental assistance or helping with that. But there are still some out there, but it is starting to dwindle down. I hope that answered your question.
It did, thank you.
Good morning, my name is Sonia Johnson and I have a question as well. I did put it in the chat box. I had a couple of questions here. Are there any provisions that prohibit a landlord from denying you the ability to view property prior to completing a rental application and paying a fee?
So no, there's nothing that's preventing you from going to see the property before you actually enter into a contract. Actually, that's actually encouraged. However, I do know when I've heard stories where when the landlord knows that the person is like coming out of state or something like that, and they tilt that power imbalance just a little bit because they know that person doesn't really have the time to actually look at it, so the person needs to sign it. I mean, those are issues. Those are definitely issues. The thing is that once you sign that contract, you are entering in that agreement, and so the courts are going to be wanting you to do your due diligence to actually see the place before you look at actually sign the contract. Now, if you get there and it's not nowhere near anything, then you can try to, terminate the lease based on the landlord breaching the lease of contract prior to you even moving in. That's definitely something that can happen, but you definitely have to make sure that all your ducks in a row. So for example, if if the lease says you have access to X, Y, and Z, you get there and there's no letters, then you can use that saying that, yes, you signed this contract, but the landlord did not they did not do what they were supposed to do on their end. So therefore there's a breach of contract and you're not going forward with the contract.
Specifically, what I'm finding is that property owners, landlord, real estate companies are requiring potential tenants prior to viewing to do a credit application and pay a fee for that process before they will allow them to even look at the property.
So that is, I'm going to assume that that's going to be that application process. They want to make sure you're eligible before you even look at the process. That's going to be more of like a gray area. If you agree to make those, again, it goes back to the freedom of contract. Like if you don't want to pay that fees and you don't want to have to, do an application background check and whatnot, then you don't have to contract with that person. But if they are requiring that for you to contract with them, there's nothing really to prevent that because they do, especially here in Georgia, they really do favor freedom of contract.
Okay, and I do understand having to go through that process should you choose to pursue the being able to secure the the property, but to even look. No, in my experience, no one's going to rent anything before they see it first. So are you obligated as a potential?
I wouldn't say that you're obligated, but I think that in your situation, that is when the tenant will have to speak up and say, I am not willing to rent here until I see the property.
Okay.
Most tenants won't do that and they'll just accept whatever. Now, the issue is, okay, if the landlord says, well, I'm not renting to you until you sign this thing. And again, that's where we're talking about, that is negotiation. You have the power to agree to whatever. They have the power to disagree with whatever until that contract is signed. So you really have to use that power of negotiating. I am not willing to sign anything unless I see the property. I don't think it's reasonable. Then the landlord in their negotiation will say, I'm not willing to rent you the property unless you do this. And then you have to make a determination of what you're willing to do and what you're not willing to do.
Got it. Clear. Thank you so much.
Mm-hmm. Any other questions? I will just say
I do have one question.
Okay.
So if you, let's say subletting is not mentioned in your lease, do you still have to let the landlord know that you're subletting the property?
Actually, if you are subletting and it is not listed in your lease, the landlord can possibly argue that you are violating the lease terms because it is not provided in the lease agreement. So if it is not in the lease agreement, I would never advise a client to go forward with subletting because that could technically be a lease violations, which could get you evicted. The other thing is that underneath Georgia law, as far as what the landlord can do, Georgia law says that the landlord, the person that is subletting, the subleaser, the landlord can treat that person as a renter or they can treat them as a trespasser. And if they treat them as a trespasser, there is no landlord-tenant relationship and they can call the law enforcement to remove them from the property. So you want to be very, very careful with subletting when it's not allowed in your lease agreement. Because one, you can be evicted for violations and there may be early termination fees and penalties surrounding you doing it. And then that person that's living there could be removed from the property without having to go through the eviction process because they don't have a landlord-tenant relationship with that landlord if that landlord hasn't accepted. They have a landlord-tenant with you. And so that the landlord can just remove them from a person that doesn't have authorization to be there. And then you put yourself in a position where one, you're violating the lease, but then that tenant can also sue you for leasing to them something you were not supposed to be leasing to them for. So any damages, their property being damaged arising out of that removal, you can get sued for that. So that is a very, like, any person that comes to me with that, I tell them, don't do it because you're opening up yourself on several fronts. Did that answer your question?
Yes, it is. Thank you.
I put my email address and my phone number in the chat. And I also, if you have any questions or you're, people that may need our help, you definitely we want them to call 1-833-GLSP-LAW. If you have more questions, because I know that this is a very complicated subject and there's always these nuances. If you have any questions, feel free to give me a call or email me. And Ms. Barbara and Shaina, I am turning back over to you. And again, we apologize for going over, but I definitely think that we were able to get the information out and answer some really important questions. So thank you so much for this opportunity.
Okay, so I would just like to turn it over. Ms. Barbara stepped out, but as you know, when we started, our director wasn't here, or our assistant director had technical, difficulties. So Dr. Sonia Johnson, who is our assistant director, would you like to say anything before we close out?
Yes. Good afternoon. Thank you so much to those of you who were able to take time out from your day-to-day to attend this very informative webinar. And I want to particularly give a special thanks to the Georgia Legal Services Programs and Ms. Meta. Is it Daisier Brown? Is that how you pronounce it? Daisier Brown. Okay, yes. The information was much needed. And I know we did this last year and it was extremely informative last year. And I just think that it's something that we need to make sure that we're continuing to kind of pound in so that people know where they can go if they have questions or if they need access to resources as well. So to both of you who were our speakers for today, thank you so much. And to our guests, thank you as well.